I would love to introduce Caitlin Sarian, founder and executive director of Cybersecurity Girl, and her father, Ronald Sarian, global chief privacy officer for Ingram Micro. They're going to talk to us about privacy, past and present, a father-daughter look at data privacy evolution.
Hello, everyone. Thank you guys so much for coming. I know it is the last day. I know we are tired. It's been a marathon for all of us, so I really, really appreciate you showing up, and I see some familiar faces in the room, and I, again, really appreciate you coming. This is our quick agenda, so we have intros, kind of where privacy began, the evolution of privacy, shifting attitudes, the present landscape, looking ahead, future-proofing, and Q&A. So before I move on, I just want to do a quick intro as to why this session is really important to me. I don't know about my dad, but it's really important to me. So just a background. So I started cybersecurity about 10 years ago, and my dad was always a lawyer, my brother's a lawyer. My sister and my mom are super creative, and I was the aerospace engineer, like right in between. Nothing to do with anyone. So I always was like wanting to relate to them in some other way besides being my family. And then privacy happened about 6 or 7 years ago. I started getting into data privacy and data protection. And my dad is obviously super smart, general counsel, and he had to start abiding by some of these privacy laws for his business. And so we started talking more about privacy and data privacy, and we've just been talking about it ever since. And as an influencer, I started realizing the overlap between privacy law and cybersecurity, and it's really all about data, but privacy obviously is about specific people's data versus cybersecurity being a lot about corporate data. And my dad teaches as a professor at University of Southern California, even though he's a Bruin, so he's been fighting on for that. But
it's been tough.
Yeah, it's been tough for him. But he has been a professor in privacy, and he started telling me all about the history of privacy and how it started, and I found it extremely interesting because I honestly think privacy is what led to cybersecurity, and we're going to kind of go through that in this presentation. But like she said, I'm Caitlin. I am otherwise known as Cybersecurity Girl. Most people probably know me as that. And I have founded and am now the managing director of my own company, and I'll let my dad introduce himself quickly before he starts.
Okay, just a little bit of background on me. I've had a kind of a crazy and interesting legal career. I was a business litigator for about 28 years, doing complex business and real estate litigation, and then I got a call from eHarmony one day, I don't know, 10, 12 years ago, and then I became general counsel for eHarmony. And it was an absolutely wonderful job, but that's how I really got into privacy, because we had the personal information of over something like 65 million users, and we had a lot of personal information, so I necessarily got into privacy and cybersecurity there. And back in 2018, we sold the company, and I left, and I went to become a general counsel for a blockchain crypto company called Euler, which was going to be an asset-backed stablecoin. Concurrently, and I was just doing all startup work with them, and concurrently I needed a day job, so I went to a national law firm, and I became the privacy chair for that law firm. Also, about the same time, I began teaching at USC Law School. Information privacy of all things. So just about a year and a half ago, I got a call from my current company, Ingram Micro, and I have been the global chief privacy officer at Ingram Micro for the last year and a half. It's been a wonderful job, very draining, very big, but super interesting. And so when my daughter came up with this idea, and it was her idea, must have been close to a year ago, it was like, wow, that'd be really fun. I'm totally up for it. So I got to thank her for putting us here. And thank you all for coming. So let's get started.
All right, so before we started, I wanted to kind of take a poll of my followers on what privacy meant, because a lot of people have no idea what privacy is. I feel like this word is thrown around similar to cybersecurity, where we kind of just, it's a buzzword now. And so some of these are literally responses from some of my followers. I had hundreds of responses I kind of picked and choose, but I think this is super interesting to just show that the definition of privacy to consumers is kind of very, wide. So someone said the trust we put into a service or company to protect our personal information. Another said that being able to have the right to determine how the data I give companies will be used. freedom to look without intrusion, trust, transparency, and choices. So I think this is really interesting before we dive into how privacy started, because right now consumers are really starting to realize that they want to be private, even though they're potentially having public profiles, et cetera, but they don't necessarily know what their right is. And so I really wanted to bring this up before we start diving into how privacy started. So.
Okay, so where it all began in the United States. Now, I'm going to be talking about the United States today. Europe has got a very different paradigm, and they were into privacy long before we were, and for many, many legitimate reasons. But preliminarily, the United States Constitution, which was adopted in 1791, has no right of privacy per se. Instead, the right of privacy came up about 130 years, well, about 100 years later, with a Harvard Law Review article by Sam Warren and Louis Brandeis. And Louis Brandeis went on to become a very famous United States Supreme Court justice. They wrote in a law review article in 1890 called, what else? The Right to Privacy. And in that, and the trigger for that article was a crazy new technology that came out in the 1890s. Does anybody have an idea any guess what that might be? Huh? Somebody say?
Yeah, the camera.
Instant photography. Instant photography,
Yeah.
Because prior to that time, you have to pose for a picture, and it would take, a minute, 2 minutes, whatever to expose, so you knew your picture was being taken. But with the advent of instant photography, we had this new, crazy, invasive, quote-unquote, technology that really required some attention. So they were really upset, or they had been affected by the paparazzi with this new instant photography, taking pictures of everybody, and they said, there's got to be some right here that's got to be protected. So, and they determined that the protection of society must come mainly from the recognition of the individual, and that's really kind of a foundation, as I see, of the United States. I mean, we recognize individual rights. And so in the Law Review article, they mentioned a number of very poignant definitions, and the right to be let alone, an individual's rights against the world, an individual's inviolate personality. A man is that which is exclusively his, and privacy itself was the right to be protected. And you need to think about all those, because that really is the core of what privacy is. Now, of course, they discussed a few exceptions, and that is, of course, if you voluntarily disclose it, that's your right. It should be up to you. And that you can be compelled to disclose in a privileged setting, such as the court. If you're on the witness stand, and the court asks you, or a lawyer asks you a particular question, you may be compelled to disclose something that's private to you. And the third, and this is the broadest category, and this is the most troubling category, and that is if it's a matter of public or general interest, or you're a public figure. So we'll get into that next. So what happened? That was in 1890. Let's fast forward to in the 1920s. And a gentleman named William James Cetus. Has anybody here ever heard of William James Cetus? Well, let me tell you about him. He was born in 1898. He was a child prodigy with an IQ of 250 to 300. It was something like 100 to 150 points higher than Albert Einstein's IQ. Some estimates say he was more like a 350 IQ. He was pushed by credentialed parents. His mother was a very famous lawyer. His father was a famous psychiatrist. He read the New York Times end to end at age 2. He spoke 8 languages at age 8. He was accepted to Harvard at age 9, but not allowed to get in until he was 11, so he went to Tufts in those 2 years. He would catch and correct mistakes in textbooks. He published, at a very young age, at least 8 books, and he became a household name in New York. But as soon as he went to Harvard, he was really horribly mocked and teased, and it was devastating to him. And here you have a 11, 12-year-old kid at Harvard being made fun of by 18, 19, 20-year-olds. So this kid was devastated. So what happened? He basically, after he graduated from Harvard, he withdrew. He just didn't want to be in the public light anymore. He wanted to be invisible. And he was happy with his anonymity. He moved from city to city once he was recognized. He used pseudonyms, and he did menial jobs. He was a machinist, he was a locksmith, he was a carpenter. And he did befriend a number of people, and he was befriended by a woman who, unbeknownst to him, was actually a reporter for the Boston Sunday Advertiser and the New Yorker. And she was working on a series entitled Where Are They Now? And he had no idea about this until the press came out, and it was about him. And she described him as ironic, leading a life of wandering irresponsibility after a childhood of scrupulous regimentation. So, as you can imagine, he was trying to get away from this, and he voluntarily got away from it. This was humiliating, and it caused him enormous stress and grief. I mean, it wasn't really true, but it wasn't really false, because he was going around, and someone's opinion was that that was an irresponsible life of wandering around. So he sues. Again, this is the 1920s. He sues, and he sues under two lawsuits. One is the New York Civil Rights Statute 51, which basically prohibits publication of a photograph for advertising purposes. And he loses. Why? Because the judge determined that he was a public figure. Now, does that seem fair? I mean, here's a kid who was put into the limelight by his parents, and he was just brilliant, so everybody, knew him. But the judge said at that time, once you're a public figure, you're always a public figure, and people have a right to know what you're doing. So, boy, so much for privacy there. He filed a second lawsuit for libel, which is just the written version of slander. But the problem was what the reporter was saying wasn't really false. So they settled for some small undisclosed amount. So the bottom line is we have no clear guidance from a civil standpoint in the, after the 1890 article, the right to privacy, and even into the 20s and 30s. From a civil standpoint, we do have defamation, of course, but that's not really the right to privacy, because truth is a defense to defamation. But if someone exposes private information about somebody, they really had no case. So instead, we get substantial guidance from a criminal standpoint. And that criminal standpoint is the Fourth Amendment, which applies to governmental entities such as police units and other governmental entities. And of course, the Fourth Amendment, and I'll read it, the right of the people to be secure in their persons, houses, and papers and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause supported by an oath or affirmation. And it goes on a little bit, but the question then became, from a criminal standpoint, what constitutes a search? Because if it constitutes a search, you need a warrant, and if they did a search and it was determined to be a search and there was no warrant, then the whole case gets thrown out from a criminal standpoint as fruit of the poisonous tree. So the focus is on what is a search. And this is where we enter into a meandering, incongruous, and schizophrenic push and pull in the criminal context of criminal law, where the right of privacy is developing in a criminal context. And so we turn to Roy Olmsted, who was a bootlegger in Oregon in the 20s, very famous guy, and all the Oregonians really loved him, but the FBI didn't like him because this was during the Prohibition. And so the FBI wiretapped him, and what they did was they tapped in a couple blocks away from his house. They caught him in a conversation. They used that, they recorded it, they used that against him, and he was convicted. But the court determined that that was not a search, which is kind of interesting. We wouldn't think of that today, though, would we? But the court determined that was not a search because there was no trespass. And trespass was kind of a core of, based the Fourth Amendment understanding of the courts at that time. There was no trespass. So what's trespass? It's basically the legal principle that you can't make an unauthorized entry onto someone's property, and really emphasize physical space and tangible property rights. No trespass, no search, no warrant required. But then here we get into the incongruous and seemingly schizophrenic area of criminal privacy law, and that is that informants, bugs, and wires are okay, which also seems a little strange. But even if an informant would come on your property, you've invited him on your property, and even though you didn't know he was an informant, doesn't matter. And the doctrine of misplaced trust, in other words, you trusted this person and he turned out to be a cop, doesn't matter. You assume the risk that anybody you talk to can be an informant. And we had a number of cases developing that. And it was not a violation of privacy because it was determined not to be a search because of the misplaced trust doctrine. Broadly allowed, and it continues today. There are some limits on it, of course, but you should generally assume that anyone can be working for the government. So now we have shifting attitudes. We're getting into the 60s now, and this is the big test that was just came down in a case called Katz versus the United States. This was a watershed case, came out in 1967. Charles Katz was a bookie, a bookmaker, who lived in Los Angeles, and every morning he would go down to the telephone booth. Y'all remember what telephone booths are? Many of you are probably too young to even remember what a telephone booth is, because I don't think we have any more, and I haven't seen them for years. But he would go down to the telephone booth on Sunset Strip every morning and place his bets. And the FBI knew he was doing that, so the FBI put a microphone on the outside, not on the inside, on the outside of the telephone booth. And he was convicted. And it went all the way to the Supreme Court, and the Supreme Court came out with a whole new test defining privacy. And this kind of equates into where we are in modern times with the internet and so forth. But there is a reasonable expectation of privacy that one has. If that reasonable expectation of privacy is violated, then it's a search. And if it's a search, you need a warrant. And they didn't do that here, so the case got thrown out and he got let go. But you needed a subjective expectation of privacy and an objective expectation of privacy. In other words, the individual needs to believe he had a right of privacy, and that makes sense. If you go in a phone booth and you shut the door, you can expect that your conversation should be private. And objective, what means, would society also expect that? Well, yes, I think generally society would say, yeah, that makes sense. I mean, you go in a phone booth, you don't think somebody's listening to you. You would expect that to be private. So, but now we go back and forth on this. So we had many criminal cases that basically parsed it out and said, well, the individual may have an expectation of privacy, but if he's committing a crime, then society would not have an expectation of privacy of that. Of course, that's kind of self-defeating, but that's kind of the schizophrenic nature of the development of privacy law in the criminal context. And then we had the third-party doctrine also in the 70s. Smith versus Maryland is a case where the police obtained information, or they did a pen register on a telephone line, and Smith argued that was a violation of his expectation of privacy, and the Supreme Court ultimately said, well, no, because you've voluntarily given your information to the telephone company. And the telephone company knows everybody you're calling, so if the cops go to the telephone company and ask the telephone company to give you those numbers, you've assumed the risk, basically. United States versus Miller is the same type of argument, third-party doctrine, that relates to bank records. Look, you give the bank your records, the bank knows what your finances are, and the bank can give it away. Now, that doesn't really seem right, but that's technically still the law. Okay, also, things within public view from the air, pollutants, within an enclosed business curtilage, U.S. versus Dow Chemicals. The police suspected that Dow Chemical was dumping toxic waste on their property. They flew over in an airplane, and they took some pictures. They saw that, and then they ultimately they said that could be used. Now, that seems like a violation of privacy, although that's a company, but a company is considered a person under the law. Marijuana being seen through the rooftop of an open roof when a helicopter flew over a roof and saw somebody growing marijuana. So there's also other permissible uses of surveillance or searches, canine sniffs, a dog sniffing, weights left in a public place, such as you leave a coffee cup and a cop goes up, grabs the cup, and you take it in and do a DNA test on it. That's okay because you left it behind. Smart meter readings or trash you've left out. But now we go back again, the pendulum swinging back. And again, we're all talking about the criminal standpoint here. Pendulum swinging back. In 2012, we had a landmark case, United States versus Jones, and that was that the Supreme Court ultimately determined that GPS tracking devices would constitute an invasion of the reasonable expectation of privacy if you're traveling in your car, because you go to so many things, they can chronicle so many things, and it was just the amount of data that was available through that. And that would be a search, even though it was on a car, people can see where you were driving if somebody was standing on the street, but they wouldn't know every single location you went to. And you'll see how this goes into cell phones and so forth. And next, in 2014, we have a case called Riley versus California, where police officers had someone under arrest, and they got that person's cell phone, and they told the person to open it up, and they started flipping through the cell phone, looking through the calls the person made and the photographs the person had and everything else. And the Supreme Court basically said, no, that's also a search, because that definitely invades the reasonable expectation of privacy. And then lastly was Carpenter versus the United States, which was cell site location data, where the police would go to Verizon, for example, and they'd say, I want all the points, I want you to give me all the location data where this vehicle's traveled, and they've used this to find if someone was in particular near the scene of a crime, and they use all that information and say, okay, but the Supreme Court said, no, that's a search, because there's way too much information in your cell site location data, because you're tracked everywhere you drive. It's invasive. So we were talking about criminal there, and now we'll see that privacy is now starting to develop, and many developments are going on in the realm of individuals, and individuals being responsible for privacy. In the 60s, William Prosser, who was a famous legal professor and author, basically came up with 4 common law privacy torts, and that was, these are wrongs where an individual can sue another individual for violating his privacy rights. 1 was intrusion upon seclusion. 2 was public disclosure of private facts. 3, false light, which means you make somebody look like somebody they're not. And 4th was misappropriation of name or likeness for commercial purposes. Now, certainly intrusion upon seclusion and public disclosure of private facts would have benefited Mr. Cetus, if you remember that, back in the 1920s. Those would be perfect for him to sue on, but those didn't exist then. Of course, existing law common principles did continue: breach of confidentiality, defamation, infliction of emotional distress, but those aren't privacy rights per se. So the present landscape. Caitlin, why don't you tell us about this?
All right. So yeah, the present landscape, like we all know, we have data everywhere. Literally everywhere. Anything that we touch is basically data points for anyone online, et cetera. So technology has continued to advance. We just keep going more and more digital. And I don't know, Dad, do you want to go through the federal state legislations?
Yeah. So now we're seeing, as I said, we just talked about the Prosser's common law privacy torts. Those were common law torts developed by the courts. But now we see the federal and state legislatures actually getting into privacy and passing laws that relate to privacy, but they're federal and state laws. California Penal Code 631, which is a wiretapping law. Revenge porn, which is a subset of that law. Fair Credit Reporting Act, HIPAA, which is, relates to your medical information. GLEBA, Gramm-Leach-Bliley Act. FACTA, Foreign Accounts Act for tax purposes. HITECH Act, Data Brokers Act. That's just to name a few. The government gave those rights, but the government also takes them away. As you all know, the United States has some very extensive and very detailed intelligence capabilities. And it started with FISA, Foreign Intelligence Surveillance Act, CALIA, Community Assistance for Law Enforcement Act, Executive Order 12333, the Patriot Act, FISA 702, Cloud Act. And the United States was engaged in rather extensive surveillance of just about every citizen in this country. The extent to which they use it, not clear. But people really discovered that with the Snowden revelations in 2013. You all remember those revelations. They were kind of earth-shaking about how much information the NSA had on all of us. And then Schrems won. Max Schrems is a privacy guru in Europe. He's an Austrian lawyer who specializes in privacy. He sued Facebook, and it invalidated what was called the safe harbor rule. And then Then there was the EU-US Privacy Shield. Again, this relates to Europe, but I'm going to tie this into what happened in the United States. That was enacted to enable, the continuance of transfer of data from Europe to the United States. Well, then he sued again in 2019 under it's called Schrems II, and the Privacy Shield was invalidated. And then we had Executive Order 14086 by Joe Biden, or the Biden administration, I should say, and now we have a brand new framework to allow the transmission of data from Europe to the United States, because Europeans, again, are very sensitive to that, and their privacy rights are way advanced over ours. And now we have a brand new act called the EU-US Data Privacy Framework. And that's currently in effect, but we expect a challenge by Mr. Schrems on that one, too. Americans did push back, too. Again, this goes to the schizophrenia, so to speak, of our government. We had ECPA in 1980, Electronic Communications Privacy Act, the CCPA, California Consumer Privacy Act in 2020, the CPRA, California Privacy Rights Act in 2023. Many, many laws, many state laws are being passed, and we don't have a federal privacy act yet, but we anticipate one by the end of the year. So the focus today is on things that are still in effect from a privacy standpoint. One is the EU cookie directive. I know you've all seen, when you go on a website, you'll see a cookie banner pop down. It'll say, "We use cookies. Do you want to accept? Do you want to reject?" That's really a European construct. There is no technical cookie law per se in the United States, although all the United States companies are, for the most part, following that law as a best practice, because that is how a company tells people what information it is being collected from them. Then we have the GDPR, the General Data Protection Regulation, on March 25th, 2018. And that really laid out the privacy regime in Europe, and it provides for all types of sanctions. And literally billions of euros in sanctions have been issued against companies like Meta and Google and all the big companies for not adequately disclosing what they were doing with people's information, okay? And so these are all based on the same principle, and it's a simple principle, and that is, if you're giving information, or if a company is taking information from you, when you go online, you have a right to know what that information is, what they're doing with that information, whether they're selling that information, and you have some degree, or you should have a right to control what they're doing with that information. Say, no, I don't want you to sell that information to marketers, right? Or you have a right to say, I want you to tell me all the information you got on me through cookies you placed on my browser. These are all kind of fundamental privacy rights that really just come into focus in the last few years in this country. Europe, again, was more sensitive to that. So we know what's going on through the privacy policies, and really primarily the cookie banners, which would have a link into what cookies are being placed. So I will defer to my daughter on the cybersecurity aspects of privacy, which are just really the flip side of the coin, because you need cybersecurity to protect privacy.
Yes. So this is what I love this slide. Everyone knows the CIA triad, I'm assuming. But this cybersecurity really started in the US in 1987 with the start of the CIA triad. And really it's because people were trying to protect, or corporations were trying to protect themselves. There was a lot of cyber warfare going on. ARPANET was created a few years before that, and a lot of people were starting to go on the network, and they were trying to protect corporate data. Intellectual property, especially the US, was really trying to protect themselves. So cybersecurity came about really from a corporate standpoint. And what I've been trying to do is flip it. If you think about it, this is all about data, but we're talking about corporate data. I want us to start thinking about personal data and corporate data. Because if you think about it, that's why I loved going through the privacy history. Privacy started hundreds of years ago, and we're just starting cybersecurity now, but it shouldn't have been the case. There's always been data about people out and about, and like my dad said, in Europe, they have a lot stricter laws, but we just started this. And so I think the CIA triad, it needs to be looked at from a personal perspective, not just a corporate perspective. And so obviously the widespread adoption of the internet, this is not just the 1990s, but the 2000s. We have e-commerce websites popping up like Amazon, and we had MySpace as like the first kind of social media happening online. We have online banking, we have all the health stuff. Everything is leading to an increase of online data, an increase of our digital footprint as for us personally, but we never really started looking at it from a personal perspective until these privacy laws started coming about, especially GDPR and CCPA. So I want to continue. All 50 states had enacted their own data breach laws. But again, data breach is, again, from a corporate perspective. It's really not for us personally. And I mean, the goal is to look ahead and get a federal privacy law, but we're going to go through that in a second. So there's so much privacy in social media. We're constantly evolving data collection. And just for you guys to understand, like, I started my own small business. I use a marketing platform, and I have a survey, I asked 3 questions. But this marketing platform, despite me only asking 3 questions, because I'm in privacy, I don't want to take people's names, emails, phone numbers, addresses, everything. I literally ask very basic questions. But this marketing platform still collects IP address, the time that they submitted. It collects so much more data. And that's because we grew up in the 2000s where data was absolutely king. We wanted to collect as much data as possible because the people that had the most data could either sell that data to someone else, and it ultimately was used for marketing and profiling. So we're constantly profiling people. We're constantly using our data, like the companies are constantly using our data for profit. And I think it's really interesting because if we're protecting companies, we need to be protecting ourselves too. So I am very much pushing, hopefully, for a federal privacy law. I know it's in the works. And this will really homogenize and unify really like diverse and disparate kind of state privacy laws. So right now, CCPA is kind of the king for the US. And I really am aiming to have all states abide by CCPA. I know, for example, in Illinois, they're really, really keen on biometric data, so they're really, really harsh on that. But there's certain states that have harsher laws than others, but I'm really hoping that the federal privacy law will, bring stuff together. And then how does AI threaten our privacy? This wouldn't be RSA if we didn't talk about AI. And also privacy is all about data, right? And AI is literally driven by data. And it's driven by our data, our personal data. And I don't think a lot of people realize that. Like every single data point is collected from online and it's collected from us. And so how is AI threatening our privacy? And just for show of hands, how many people know that how much data is online about each of us individually? Has anyone Google searched on the white pages, specifically in the US? Anyone? Okay, yeah. I mean, for me personally, even though I'm in privacy and my dad's in privacy, all of my data is out there online. And there are a few companies, I use Delete Me to delete it all, but we constantly have all of our data online. Our personal data, if you buy a house in the US, you are obligated to give all your information. The DMV sells our data to other companies, and it's not in the US. They sell our data everywhere outside the US. It's very weird. So AI can easily threaten our privacy because, like I said, the US is not strict with who we give our or who they give the data to. I don't know why. I'm hoping this federal privacy law comes about. But what we don't realize is AI is not just ChatGPT, right? AI is anything, any profiling, any type of way that they can analyze our data and then come up with a solution to a problem, right? So there's a lot of new AI regulations that are part of kind of consumer privacy bills, and I'm not going to go through every single one of them. But for example, I'm obviously too far away, but the Illinois one is the bill would regulate collection and processing of personal information through algorithms, which is super important because I know that's being done right now. A lot of people don't realize that AI is being used to profile us. So for those of you guys that don't know what profiling is or shadow profiling, it basically looks at everything that you do online, your digital footprint, and says, for me, I'm a white, or I don't know if they'll get really detailed, I'm an Armenian female in my 30s in this city, liking this stuff with a cat and all this stuff. And I am specifically profiled. And they use those profiles to then make decisions. And that's what AI is doing. It's not someone behind the keyboard. So AI actually is really infringing on our privacy, but it's only infringing on our privacy because we allow it to. We allow the government to sell our data. We allow the government to collect our data. So I think it's really cool and important for the federal government to start enabling and enacting a federal privacy law, which limits the ability to give all this data. And so there's more AI privacy laws for healthcare, and that's a lot of times we don't realize, but they're using AI to actually diagnose a lot of people. And so there's some bills, I think, I obviously can't read it, but there's a few bills that are going on where going to limit the AI to have the ability to actually have a diagnosis, or it'll allow a nurse practitioner to overrule what the AI is saying, because we can't just let AI run everything. But it's really, really important to understand that privacy is completely tied with AI, and if we continue to let all of our data go, and we're okay with letting all of our data go, then that all goes to driving more, integrated AI, which could be a good thing, but also it's infringing on our personal life.
Let me just interject for a second. As Caitlin indicated, you've consented to all this data being used. And the reason is because in the United States, consent is implied. In other words, a website can put cookies on your browser and do whatever the hell they want to do with your data, unless you specifically tell them you don't want them to do that. So that's why it's just super important to read the cookie banner and see what type of cookies are being placed on your browser. Because, again, you're consenting to it unless you tell them no. So Europe is completely different. Europe, you can't put any cookies on a browser unless there's express consent before those cookies are placed. The United States may get there one day, but I don't think so. I think we're more commercially focused, because that does create all kinds of issues for digital marketing, which is an amazingly powerful tool, for lack of a better term. But the bottom line is you've consented, so key is look at the privacy policies, look at the cookie banners, and see what's going on, and make your choices in that regard.
Yeah, and I will say, obviously, with CCPA, we do have our own rights now, so hopefully if the company is abiding by CCPA, it's not as stringent for some of them like GDPR, but we do have the right to ask what data they have. We do have the right to delete it. But again, it's us going out and being proactive and asking. Yeah. And it takes a while, and a lot of companies aren't fully able to comply. And from a company perspective, I get it. I was a consultant for 10 years. It is extremely hard if you actually think about all of the data they collect from every single team to actually abide by this. But I think, hopefully in the future, when it's built correctly, that it will be a lot better. But I think that's why we need to have federal privacy laws start now, because if we're waiting so much longer, we're going to continue to collect more and more data, and it's going to be a lot harder to actually enact and enable these privacy laws. So future-proofing privacy programs. So there's 3 essential strategies that I always recommend as a consultant when I used to do consulting. One is assessing and reducing the current risk landscape. And we'll go through these in the next few slides. The second is automating core processes. And the third is creating scalable programs and staying informed. As you could probably hear and see, privacy is constantly changing. We have to be agile and we have to be able to move. And the issue is when we're so data-driven and so data-heavy, it's really, really hard for large companies like Meta, et cetera, to actually abide by these privacy laws. So enabling these strategies, and I understand it's consultant, big buzzwords, I get it. It's a lot easier said than done, but hopefully with these approaches we can go through it. So the first is a lean data approach. Like I said, data used to be king, and now we're trying to reel it back and really only collect what is necessary. And so for companies out there that are trying to do this, what you need to realize is every single team, I guarantee you every single team is collecting some type of data. And so you're gonna need to go to every single team. HR is collecting employee, potential employee, any LinkedIn data, any financial data, payment data, health data, anything like that, they're collecting. Engineering team, your SOC team's collecting threats, your engineering team's collecting any bug issues potentially on the website. Marketing is the worst one. I don't think people realize, because it's not a tech thing. Marketing is collecting everything. Most of these marketing teams even are collecting how long you're hovering over a button. There's so much data.
Yeah, and by the way, core concepts of the GDPR as well as the CCPA is that companies should not be profiling you or making automated decisions based upon cookies and so forth that are placed. Now again, that's a huge dilemma for digital marketing, because that's the whole point of it. So it's a really difficult and interesting area we're in right now with regard to the automated decision making and profiling aspect, especially with AI.
Yeah. And so again, go to every team and understand what data they're collecting and ask a million questions, because a lot of times when you ask the first few times, they're gonna be like, no, I don't collect anything, I don't understand. And since you don't really understand what they fully do, I would literally walk through what their day-to-day looks like and start realizing all the stuff that they're doing every day, so you can start understanding what they're collecting. Because again, people that aren't in cybersecurity or privacy specifically aren't going to start thinking like us. They have no idea what we're talking about, and they just think that they're doing their day-to-day stuff. So it's really working with them and trying to understand and prioritize data minimization. So what do they need to collect, and what can they like either delete off of the system and not have to collect again? That is huge. And then it's adopting stringent privacy laws. So as of right now, GDPR, CCPA, they're all the most strict. And then it's risk identification and mitigation, which is, again, regular data privacy impact assessments. I didn't put this in there, but third-party assessments are absolutely a huge thing. Like third-party, I mean, we can see SolarWinds, we can see the Okta breach, everything. Third-party breaches have been really driving a lot of data breach and privacy issues. And so, making sure that you have those proactive approaches of doing that. Automating core processes. I know I wanted to give some time for Q&A, so I'll try to speed up a bit. But data subject request automation. Feel free to take pictures. Monitoring, reporting, like real-time compliance dashboards. There's so much that you can do to automate. If you guys go downstairs and look at all the vendors, right? There's a solution for every problem. And let's just try to automate it as much as possible. But I do want to recommend one thing. If you have a solution and you're getting alerts and you aren't looking at it, I would rather have you turn off the solution. It looks like it's very negligent for people to be running the solution and not actually looking at the issues. So I saw that a lot as a consultant, and I was like, I'd rather have you guys put it at shelfware until you can have someone that actually monitors the solution. Because if you ever get into a data breach and it shows that you guys were ignoring this for so long, it's a really, really big red flag, and the company's probably going to get into a lot of turmoil.
Yeah. Regulators look at making sure that you've properly trained your employees to understand data implications and data privacy. So it's a critical component of all the laws, the CCPA and the GDPR, again, which we're not really talking about. But one of the core components is that people who deal with data need to be adequately trained to recognize issues.
Yeah. And then the last one is creating scalable programs and staying informed. I think they're both really important, and I don't have that much time. So scalable privacy frameworks, again, be flexible. It continues to change. And if your company is pretty large, I would definitely have someone sole responsibility of scaling your program and making it more efficient, and constantly just going back and making sure it's working properly, because it's big organizations, it's really hard. And then staying informed. Go on LinkedIn groups, be friends with other CISOs. There's tons and tons of groups out there that help with this stuff, and find them. And even I think the FBI, there's a lot of groups that you can join that really tell you the threats that are out there for your company.
Yeah, it's good to have a contact with the FBI. I know we did that at eHarmony. We knew their local agents. They'd come by, we'd talk to them, because there were romance scams going on, and they would tell us what to look for. And if we wanted to modify or further develop any particular algorithms to spot this kind of stuff, it's really good to have a relationship with them, because if there is a data breach, depending on the circumstances, you may want to call them. Or if there's some type of a ransomware attack, they often, if they get early notice of it, they can do something about having or freezing funds from leaving bank accounts.
Yeah. And then overall, I'll give my closing remarks, and then I don't know if my dad has any more, but I really want us, as at least the US, to start focusing and realizing the importance of personal data, not just corporate data. And honestly, a lot of corporate data is personal data. It's our personal data, right? So it's like two sides of the coin. Corporate data is personal data and the company's data, and then personal data outside of the company is all of our data. So the CIA triad really should be thought about from the two perspectives, both corporations and for personal. And I honestly can't wait for the federal privacy law to come out, but I feel like I have too high of expectations for that. But I just want us to all remember, privacy started a long time ago. We all have the right to privacy, and although the US is in this weird transition phase right now, I think ideally it would be, it's going towards, more privacy rights for us as a consumer, which I think is the most important thing. Rather than corporations, because corporations kind of drives the U.S. economy, which is why it's so important. But if we start realizing how important our personal data is, then it's I think it will be a lot easier.
Yeah, The bottom line is today that, we are much more aware of our privacy rights, vis-a-vis the internet and so forth. And as I indicated earlier, I mean, most states now have privacy laws, if not in effect, actually passed and waiting to go into effect. And hopefully by the end of this year, we'll have a federal data privacy law that actually does provide an actual right. Again, it's not in the Constitution, but does provide a right to privacy. Now, California Constitution has a right to privacy, and some other states do, but from a national basis, it's going to be great once we get a federal law passed, because that'll put a uniform gloss on all the privacy regulations and supersede any inconsistent privacy regulations.
Yeah, and at the end of the day, I feel like it's our right and our responsibility as well to teach and educate the public on how they can be safe online until these privacy laws get enacted too, which is why I love being able to, share how to do this online. But yeah, just continue to remind people about their privacy laws. I know, privacy is always top of mind for everyone. We all get really excited about privacy. And yeah, thank you guys so much. We have 5 minutes for questions. I didn't know if anyone had questions, but I appreciate you guys for coming.
Thank you so much. We're honored to be here.
Oh, yeah.
Hi guys, thanks
Hello.
for sharing. I'm Talia. I get to work with the Federal Information Security Management Act, and I was wondering if, pie in the sky, if we got to make recommendations for federal policy, the one thing that I've noticed is missing, and I know we all move slowly, is there's very little crackdown on dark UX, and a lot of people have to opt out specifically, and that assumes a lot of knowledge. Or they think that their location is just being used to add a cool tag and don't think through the implications. But if you could make recommendations for the most important policy we could try and push for, you can each say one pie in the sky wish.
Yeah, I mean, oh, that's so hard. I think for me, it's more of a timely thing and an education thing for consumers. So consumers don't know what's going on unless they're told. And obviously there's the rules around privacy policies right now, but they're not clear even though the laws state that they should be clear, and they're not transparent. And I think there should be a federal push to have consumers understand what's going on and overall education as to what's going on and why it's important before as part of a privacy law. So not a privacy law from a corporation perspective. Obviously corporations need to abide by the privacy law, but for me it's a privacy law from a federal perspective of educating the public on, hey, FYI, because this is our law, this is what's happening, this is the data that they're collecting on you, this is what you can assume, so here are your rights. And I don't know if that's ever gonna happen, but that would be the pie in the sky for me.
Well, the rights are supposed to be laid out in the privacy policy, but so often, privacy policies are very long. Sometimes they're 10 pages, they're single space, and nobody wants to read
Thanks
them.
to lawyers.
Yeah, thanks to people like me.
Exactly.
But so often, a business would have additional FAQs, frequently asked questions, giving customers a knowledge of particular areas they ought to be concerned about and what they ought to be looking to and looking to avoid.
That may be one of the places where AI could actually play a meaningful role, because one thing that they're quite good at is summarizing, 10 pages of legalese,
Yes.
and maybe enforcing a summary, whether it's from a human or from an AI.
Yeah.
Anyway, thank you for your thoughts. I'll cede my time.
Thanks for your question.
Yeah.
Hi, Krissa Freeman, Code 42. We're a business-to-business company, and so we don't directly collect data from individuals, but our customers might, and then we hold it. And so one of our big pain points is data deletion. So curious on your thoughts if the federal law that's coming, if that's going to mandate companies that are producing the tools that our data is going into to automate that deletion, because right now to manually go in and delete, it's just not feasible. There's not enough time in the day, there's not enough people to do it. Any thoughts on that?
Yeah, well, data deletion is one of the most difficult things any company's got to deal with. I know that when I was at eHarmony, we had so much data, and it was a lot of work to figure out, how long, because it was in so many different silos in so many different places, which is why you need to do data mapping, which is a requirement of GDPR and the CCPA and so forth. You need to know where all the personal data is. And then once you know where it is, you have to come up with a way to either delete it or anonymize it.
Yeah.
And the deletion is a lot of times really, I said it's difficult, but sometimes you'll delete something, it'll screw something else in the system up. I know we went in eHarmony, we deleted a bunch of data because it was old and the people hadn't been on the site in a particular period of time. And when we deleted the data, it screwed up a whole bunch of other things. So my only advice to you is it's a real technical area. You need to get together with a good IT person. You have to have a good data map. You have to know where your data is. And then you got to figure out what data you want to hold for what reasons. Like, do we need to retain this data to defend ourselves? Because that is a defense.
Yeah, I know we have to stop.
Yeah.
The other thing is, one last thing is, if it's third parties, like bake it into the contract that it's their responsibility and that there's an easy way for you to communicate to them and an easy way for them to confirm that they've deleted the data that they said. That way it kind of legally, you can check the box saying, hey, they've sent a confirmation that the data is deleted. This is the best that we can do. Anyways, I know we have to stop, but thank you guys so much.
Thank
I
you.
really appreciate it. Enjoy the last few hours of RSA.
Thank you so much.